So I want to ask you about your objections about excessive time entries and conferences and so forth. So my first question is, have you ever been an attorney in a bankruptcy proceeding before?
No.
Do you have a legal background?
No.
Have you ever acted as a trustee in a bankruptcy proceeding?
No.
Have you ever participated in a bankruptcy proceeding before this?
No.
I asked you earlier about your experience with 1031 exchanges and some questions about that, so I want to kind of circle back to that because one of the bases on which you've objected to the fee application for the trustee and his advisors is the way in which 1031 exchanges were handled.
Correct.
So now, did you participate in the discussions between the trustee and other exchange accommodators concerning whether or not they would handle exchanges that some of the accommodators had been involved with?
No.
And in fact, you've never seen an exchange agreement before, have you? Isn't that what you told me earlier?
I have now.
But you hadn't before the bankruptcy was filed?
Not before the bankruptcy was filed.
And did you ever participate in the mechanics of a 1031 exchange before the bankruptcy was filed as an accommodator?
No.
Other than assigning out work or exchanges to other exchange accommodators, what would you, in the basis of your objecting to the fees, have had the trustee do differently with respect to 1031 exchanges?
Other than hire somebody who knew what they were doing?
Other than having other exchange accommodators come on board?
That would be the only thing I would suggest.
Okay. Were you involved in any of the discussions between the trustee and the shareholders of Summit with respect to their transfer or potential transfer of assets to the trustee or to the estate?
Yes.
And what was your involvement?
The presentation that Kevin gave us on the 12th of February.
Okay.
I had some emails with Miss Vivian Paparel that had probably information on suggestions of how to transfer assets that I believe she turned over to Kevin. And I had phone calls with Kevin about various things like the bond, like getting things done quickly, and doing it in a way that keeps the value in the estate.
And what was it that you told Mr. Padrick he should be doing, if anything, differently than he was doing?
That he should put the properties in 3 different buckets. 1, foreclosing properties with no value. 2, I think it was properties that the shareholders own 100% of that, can go over right away. And 3, ones that have other partners that would cause a decrease in value by a global transfer.
Anything else?
No.
And you were one of the other partners in that third bucket, correct?
Yes.
Did you ever attempt to perform a valuation of the assets that were held by the shareholders that were transferred over to the trustee?
Yes.
And how did you perform that valuation? What did you do?
I did an Excel spreadsheet off of the spreadsheet that Tim Larkin prepared that Obsidian kind of added to. I took from that, then I adjusted the numbers based on asking people questions and gave it to the U.S. Attorney.
And when you say asking people questions, what do you mean by that?
Like, for instance, if I didn't know what the value of a property was in Arizona that Bruce Thompson owned, I called Bruce and asked him.
Anything else that you did other than calling Mr. Thompson or?
I talked to Brian, I talked to Mark, I went through every one to see how they were owned. I could see by the schedule kind of how they were owned, and just went one property at a time.
Did you do any analysis of comparable sales in the market?
I didn't have time to do that, no.
So it was either based on information that was already in the schedule or updates to that information you got from talking to either partners in the particular LLC or other members, I should say.
Correct.
Or talking to the Summit shareholders.
Correct.
Did you have any discussions with any of the Summit shareholders about any concerns that they expressed in terms of transferring the assets over to the estate?
Mostly the exact same concerns. What we talked about at the presentation, which was transferring assets that were prohibited transfers, and the 3 different tranches of assets that were supposed to be transferred.
Did they ever explain to you any concerns they had about the transfer of assets potentially resulting in claims being brought against them by other parties, including Umpqua Bank?
No.
Or any statements made to them by anyone representing Umpqua Bank about the impact of a transfer?
No.
And do you know whether or not that interfered with the efforts to get a transfer of the assets?
I don't think so. I don't know.
Just shifting gears a little bit, did you ever become aware of the Summit shareholders having any discussions with Umpqua Bank beyond just having a banking relationship with them?
I did after.
And sorry, let me ask it differently, okay. Prior to the bankruptcy filing, did you ever become aware that the shareholders were having discussions with Umpqua Bank about a relationship sort of beyond the general banking relationship?
No.
Did you understand at any time prior to the bankruptcy filing that the shareholders were making efforts to try to secure either some kind of a strategic alliance with the bank or any other kind of broader relationship with the bank?
No.